Let's start with a simple question. If something happens to you, who decides what happens to your things? You do, if you have the right documents. Most people have heard about wills and living trusts, but many folks aren't sure which one to choose or what each one really does. Think of your assets like a big box of personal treasures. A will is like a letter saying who should get what when you're gone. A living trust is like a locked storage chest. While you're here, you hold the key and decide what goes in. When the time comes, you've already picked someone else to get the key, so they open it and follow your directions without asking the court for permission. Let's compare wills and living trusts, focusing on how they work in Florida. A will is simple. You write down what you own and who should get your stuff. You can name someone you trust, called a personal representative, to carry out your wishes. But here's the catch: a will must pass through probate. Probate is like airport security for your will. The court checks everything, makes sure your instructions are clear, and lets only the right people through. Sometimes this is quick, sometimes it takes months, and there are fees each step of the way. Even a straightforward estate might get delayed if the court has a heavy load or if there's confusion. With a living trust, you move your assets into the trust while you're living. Picture moving your valuables from the box to the locked chest with you as the keeper. If something happens, the new person you picked, your successor trustee, opens the chest and follows your instructions right away, usually avoiding the probate court entirely. Your family sidesteps the long lines and extra checks. This is especially helpful if you own real estate or have property in more than one state, because trusts move smoothly across state lines. Privacy is another key difference. Probate records are public, so anyone curious can see them. Wills become public too. A living trust stays private. What you own and who inherits stays between you and your trustees. People often ask, is a living trust only for the rich? Not at all. Trusts help in many common situations. Let's say your goal is to keep things simple for your spouse or kids, or if you have minor children. With a trust, you choose how and when your assets pass along. For example, if your children are young, the trust can hold money for them and release it at certain ages or milestones. If you want to protect vulnerable beneficiaries, a trust gives you more control. A will by itself won't give that kind of protection. It tells the court who gets what, but after probate, those people get the property right away, even if they're too young or facing tough situations. Let's talk about cost. A will is less expensive up front. Most Floridians with small, simple estates pay less for a will than a trust. But after you're gone, your family pays probate fees. Those could be thousands of dollars, especially if the estate has real property. A living trust costs more to set up. Think of it as buying the storage chest and a good lock. But if you keep it updated and do the paperwork right, your family avoids most court costs later. For many, the upfront expense of a living trust makes sense for the peace of mind and savings over time. Asset titling is critical. Your trust only controls what you put in the chest. If you forget to move your house, bank account, or investment into the trust, it stays outside and might face probate after all. Some assets, like retirement accounts or life insurance, already let you pick a beneficiary. With these, the beneficiary form usually decides who gets the asset, not your will or trust. Always check these forms and update them as your life changes. A living trust also helps if you become disabled. If you're unable to manage your finances, your chosen successor trustee can step in without the court appointing a guardian. This spares your family more paperwork and stress. With only a will, no one can help manage your assets unless the court says so. Now, are there any downsides to living trusts? A trust costs more to create. You have to retitle your assets, more upfront homework. If you skip this, the trust loses much of its value. Also, a living trust does not protect assets from Medicaid if you need nursing home care in Florida. For that, you need different planning tools like an irrevocable trust, which comes with its own rules and downsides. Some people do fine with just a will. If your estate is small, you own everything jointly with right of survivorship, or all your accounts have up-to-date beneficiary designations, probate may be simpler and cheaper. For these families, a will and good asset titling may be enough. But if you want more control, privacy, or to avoid court delays, a living trust gives you a smoother path. Think about your family's needs, your assets, and how much effort you want to put in now for a simpler process later. Whichever you pick, will or trust, make sure it fits your life. Update it when you buy a home, have children, lose a loved one, or your wishes change. The most important step is not waiting until it's too late. With a proper plan, you set your family up for the smoothest transition possible.